that as per his averment, he has not annexed, he has neither named any person nor he has annexed any document.
Yes, the petitioner by way of this writ petition claims promotion on the post of Deputy Superintendent of Police on the ground that persons junior to him have been promoted on the said rank. Counter affidavit has been filed and it has been stated that the petitioner was promoted as Inspector of Police in the year 1999 and none of the police inspectors promoted in the year 1999 have been further promoted to the rank of DYSP before the date of superannuation of the petitioner, that is 31/10/2011. In view thereof, the case it has been paid by learned counsel appearing for the respondent that the petitioner does not have any rightful claim. I have considered the submission and heard learned counsel for the petitioner. The petitioner has not been able to show any document of any junior police inspector promoted along with him in the year 99 or thereafter to have been promoted as DYSP prior to his retirement on 31/10/2011. As there is no discrimination on part of the respondents and no other person has been promoted over and above the petitioner, below the petitioner, prior to his retirement, claim of the petitioner is not made out, writ petition is dismissed.
Item number 25, Mr. Umesh Chandra Burma.
My lord, it's a matter of cancellation of the post of Anganwadi Sevika, my lord. It has been decided by the Honorable Court, my lord, in CWJC number.
Dismissed.
Item number 26, Mr. Ram Vijay Prasad. In this case, my lord,
Yes.
prayer is to set aside the order of dismissal of father of petitioner, Annexure 6, and order of DIG of police, Annexure 8, by which appeal has been rejected, my lord.
When did he expire?
He expired on 29/12/11, my lord. विडो भी नहीं थी, विडो भी 2007 में डेथ कर गई, तो सिर्फ यही लड़का था, बेटी भी माने थी, नाबालिग थी. So this petitioner, son of original employee, my lord, filed this case, my lord, to set aside the order of dismissal. In this case, my lord, if this writ will be allowed, my lord, then he will get some benefit, my lord, of father, my lord.
More delay and latest, 2005 order, my lord, and 2009 order in challenge 2013, my lord. After date of the, my lord, implies.
My lord, of course, my lord.
Allegations are very serious, my lord, against the police.
That is another thing.
ठीक है, उस पर भी हम आ रहे हैं.
On ground of delay, we are dismissing it.
Delay तो नहीं हुआ है, my lord.
Why? After 2009, he should have filed a writ petition if he was so much. And
My lord, my lord. On
He expired in 2011?
Yes, yes, my lord. On 27/1/2009, appeal has been rejected, my lord. Thereafter, due to poverty, my lord, he could, the father of the petitioner could not be treated, my lord, and ultimately he died on 29/12/11, my lord.
He was suffering from what?
अब यह तो
आया
नहीं आया my lord.
तो
There is no
क्योंकि
prison, my lord.
वो
it is not in your
scheduled
case
tribe,
that he was unwell.
he was a member
अगर
of
आप ये
scheduled
कहकर आते कि वो बीमार थे 2009 के बाद, तो ये तो भी नहीं आप कह कर आए।
my lord. वो तो उसका लड़का आया तो हमने फाइल किया
नहीं, वो तो आपने तो सही टाइम पे फाइल कर दिया।
my lord.
लिखिए
Date नहीं हुआ, my lord.
petitioner
सिर्फ दिसंबर 11 में डेथ किया और हमने फाइल किया 2013 में my lord. चूंकि रांची उधर के रहने वाले थे, शेड्यूल ट्राइब मेंबर थे, इसलिए डिले हुआ, कुछ अगर हुआ तब। और इसमें इंपॉर्टेंट पॉइंट माय लॉर्ड है कि ऑर्डर ऑफ कमांडेंट विदाउट कंसिडरिंग द पॉइंट्स रेज्ड इन द सो कॉल एंड नेक्स्ट वेरी वाइटल पॉइंट दैट रिपोर्ट ऑफ इंस्पेक्टर भवन राम वाज रिलाइड अपॉन अगेंस्ट द
Yes, sir.
फादर ऑफ petitioner विदाउट प्रोड्यूसिंग।
क्या चार्ज है?
चार्ज मतलब एक औरत के साथ उनका गलत
How is it with the कौन सा मिसकंडक्ट है?
चरित्रहीन का चार्जेस,
हाँ?
चरित्रहीन मतलब कैरेक्टरलेस का।
How do you say that he is characterless? If suppose somebody has some relation with someone else?
तो पार्वती देवी alleged my lord,
Hmm?
पार्वती देवी
पार्वती देवी?
के साथ उनका संबंध था।
Hmm. And she came to you.
मतलब then charges has been framed my lord and departmental posting in magistrate
And
he had,
Parvati Devi came to the inquiry.
my lord, he admit, petitioner himself admit, petitioner father himself
So
admit.
all right.
admission is,
Suppose
my
if
lord.
he has some relations with some lady who is a widow, how is it a misconduct in course of duties?
एनेक्सरिएट अपीलेट ऑर्डर का जो पढ़ देते हैं लास्ट में, अपील करता द्वारा समर्पित अपील आवेदन संचिका में उपलब्ध कागजात।
आप कह रहे बहुत सीरियस चार्जेस है। We want to know from you.
मतलब
If suppose somebody
पुलिस पर्सनल में थोड़ा सा जो सोसाइटी में तो
क्या आप मॉरल ले डाउन करेंगे सोसाइटी में? To tell us how it is a misconduct under the conduct rules.
यह काज आपका अनुशासनहीनता एवं कर्तव्यहीनता है, दुराचार।
Who has made a complaint to you? His wife came? His wife had already expired? And if he suppose has some relations with some widow, how was it you can, other side you are allowing live-in relationships?
Somebody my lord,
How can that be a misconduct? I have already held so. A detailed judgment given by me in Rajasthan.
चार्जेस में जो चार्जेस है बस उसी पर इनका इंक्वायरी हुआ है।
That was also a case of a police officer only. He was having relations with some other lady constable. Both of them were dismissed. I have held that such dismissal is bad in law, and that has been upheld by Supreme Court all the way. Bring that judgment. Then his son has a right, he has rightly come to the court. If you make such allegations and dismiss a person from service, that also affects his public image, and it is tarnished. He will come to the court even if he does not get any individual benefit. We will allow him.
This conduct is not during course of duty, my lord.
You get that judgment?
My lord.
No.
एक तो
Some
है
Chaudhary. If I remember, I don't remember my case.
एक तो है कि डोमेस्टिक
we have
डोमेस्टिक क्वेरल,
there is
प्राइवेट क्वेरल है my lord.
with this Navtej Singh's judgment which has come from Supreme Court.
My lord.
After that, I have given a judgment. Justice Chanchur's view taken relating to
My lord. एक जजमेंट है
law ही बट बदल गया. Mister, where are you? Next week लेकर आइए.
My lord.
23rd.
I have given this, my lord. I have given the slip case number.
हाँ, उसको लगवा लीजिए कल.
मंडे को लगा दिया जाएगा. इन्फॉर्म
ऑनलाइन लगवा देते हैं.
इन्फॉर्म कर देंगे.
हाँ, उनको इन्फॉर्म कर दीजिए कल ऑनलाइन लगवा के उसको फिर जिससे सैटरडे संडे में दिखा देंगे ना.
बता दें.
Item number 27, Sachidanand Kishore Prasad Sinha.
This petition successor.
Council states that the writ petition rendered dismissed accordingly.
28, Mr. Jitendra Kumar Rai.
In this case, advocate on record, Mr. Jitendra Kumar Rai has died.
Counsel for the petitioner expired has stated to have expired. No one appears for the petitioner. Petitioner has not arranged any other. Has not needed other arrangement. Dismissed for non-prosecution. Can you?
Client is consulted me to fresh it.
29, Mr.
Has he consulted you? आप वकालतनामा लगा रहे हैं?
फ्रेश हमको अभी मिला नहीं है, लेकिन फ्रेश हमसे क्लाइंट
देखिए, आप करेक्ट बात बोलिएगा.
जी
आए हैं क्या वो? कब कलेक्टर आए?
आज हमसे कंसल्ट किए कि मतलब आप प्रेस कीजिए इसको, तो अभी वक्त नहीं.
नॉन प्रोसिक्यूशन हटा दीजिए. देखिए, द काउंसिल अर्लियर काउंसिल एक्सपायर्ड. द learned counsel submits that he has been instructed to file wakalatnama and wants time to argue the case. List again on 6th of February.
अब नहीं.
अपनी नाम दे दीजिए.
प्रशांत कुमार.
Item number 29, Mr. Umesh Chandra Verma. Umesh Kumar Verma.
Application for quashing the order dated, my lord, 21/5/2011, my lord, annexure 17, my lord, by which the learned collector has passed the order, my lord. One annual increment has been withheld, my lord, with non-cumulative effect, my lord, and no other payment except subsistence allowance has been paid, my lord, during suspension period, my lord. The third punishment, my lord, the punishment order be entered in the service book of the petitioner, my lord. Actually, my lord, the petitioner was appointed.
What is the charge sheet?
Yes, my lord. Thirdly, my lord, petitioner was suspended, my lord, by annexure 4, my lord, on the recommendation of SDO Rajgir, my lord.
Yes.
And charges have been framed, my lord. By annexure 5, my lord, page 30. There are 8 charges, my lord. And that proceeding, my lord, punishment was awarded, my lord. 2 increment had been deducted, my lord. That order was, my lord, challenged before the Honorable High Court, my lord, by annexure 9, my lord. Writ petition was allowed and matter has been remanded, my lord. Writ order, my lord, annexure 9, page 48, my lord.
Yes.
Thereafter, my lord, fresh inquiry has been held, my lord, by annexure 10, my lord. Petitioner has given reply, my lord.
Annexure?
Annexure, my lord, 13, my lord. Annexure 12, my lord, page 56. विभागीय कार्रवाई के पूर्ण संचालन हेतु स्पष्ट कारण परीक्षा की मांग. Then, my lord, the petitioner has submitted his reply, my lord. No, sorry, my lord. Annexure 13, my lord. आरोप जो है सो है हुजूर, उसका जवाब है.
फ्रेश आरोप लगाए क्या?
फिर आरोप सेम वही पहले वाला हुजूर, क्योंकि जो रिमांड हुआ.
इंक्वायरी ऑफिसर को रिमांड किया था ना मैटर बैक.
जी हाँ, लेकिन फिर से हुआ, फ्रेश कहा गया था. फ्रेश कहा गया था, फ्रेश
कोर्ट ने ये
फ्रॉम द
कहा
चार्ज।
इट इज रिमांडेड टू द इंक्वायरी ऑफिसर
जी,
to proceed afresh from the stage of framing of charges.
यस माय लॉर्ड,
And conclude the departmental inquiry.
यस माय लॉर्ड।
So where is that departmental inquiry report?
फर्स्ट वाले माय लॉर्ड।
इसके बाद
जी, वो हुजूर हम बता
इंक्वायरी रिपोर्ट है वो कहाँ है?
हाँ, यस माय लॉर्ड, आई हैव नेक्स्ट माय लॉर्ड, एनेक्चर 15 माय लॉर्ड, पेज 73, जिसमें पहला आरोप जो हुजूर कहा जाता है पेज 74 पर है, स्पष्ट कार्य प्रणाली त्रुटिपूर्ण हो गई जिसका प्रधान सहायक एवं अन्य द्वारा संज्ञान नहीं लिया गया। मिडिल से थोड़ा नीचे है माय लॉर्ड, पेज 74 पर माय लॉर्ड, चार्ज आरोप नंबर 1 का, पेज माय लॉर्ड 74।
Then what happened?
इसी तरह माय लॉर्ड, देयर आर 5 चार्जेस हैज नॉट बीन प्रूव्ड माय लॉर्ड। काइंडली सी माय लॉर्ड, पेज 75 माय लॉर्ड, ये कहा जाता है कि प्रधान सहायक के हस्ताक्षर के पश्चात ही पदाधिकारी द्वारा हस्ताक्षर किया गया है जिससे किसी गलत मंशा की बात नहीं लगती है।
Then आरोप सही नहीं
जी,
प्रतीत होता है।
2-3 आरोप के बारे में कहा जाता है। आरोप
आरोप
नंबर
संख्या 4 में भी थाने का आरोप सही प्रतीत नहीं होता।
नहीं होता है। 5 भी हुजूर, जिससे कोई तथ्य छिपाने की बात सही नहीं लगती है।
कोई तथ्य छिपाने की बात।
यस माय लॉर्ड।
ऑल राइट।
आरोप संख्या 6 में हुजूर कहते हैं, अतः आरोपी एवं तत्कालीन प्रधान सहायक दोनों पदाधिकारी को दिग्भ्रमित करने का दोष ढोते हैं।
ये आरोप प्रमाणित नहीं होता है। 6 भी
जी, 5 आरोप कहीं प्रमाणित नहीं हुआ हुजूर। 6ठा में कहा जाता है जी, 6ठा प्रूफ हो जाता है हुजूर। और 7वां भी कहते हैं कि जिसका सत्यापन प्रधान सहायक द्वारा भी हस्ताक्षर कर दिया गया था।
दिस इज ऑल्सो प्रूफ।
ये और 8वां कहते हैं कि आंशिक प्रूफ होता है। अतः यह आरोप, पेज 77 पर माय लॉर्ड, मिडिल पार्ट माय लॉर्ड, अतः यह आरोप अंशतः प्रमाणित होता है।
पार्टली प्रूफ।
जी, पार्टली प्रूफ। ऑन दैट बेसिस माय लॉर्ड, पनिशमेंट हैज बीन अवॉर्डेड। 1 annual increment has been deducted my lord by annexure 17। निरपेंद्र, लास्ट में हुजूर पेज 83 पर माय लॉर्ड, निरपेंद्र कुमार लिपिक का एक वार्षिक वेतन वृद्धि असंचात्मक प्रभाव से रोका जाता है। निलंबन अवधि में श्री निरपेंद्र कुमार लिपिक को जीवन निर्वाह भत्ता के अतिरिक्त कुछ देय नहीं होगा। इस आशय की दृष्टि इनके सेवा पुष्टि कर दी जाएगी। देयर आफ्टर माय लॉर्ड, the petitioner had challenged the order, my lord, before the divisional commission, my lord, which was confirmed by annexure 18, my lord. Then, my lord, the petitioner has approved before lordships.
And the commissioner has also
Confirmed, my lord.
confirmed, right?
Yes, my lord. Lordships, kindly see the annexure, my lord, 7. Page, my lord, 41. वीडियो से रिपोर्ट मांगा गया था हुजूर बाय एनेक्चर 7 सीरीज से माय लॉर्ड, पेज 40 से, सॉरी माय लॉर्ड, सॉरी एक पेज आओगे सर, 39 से माय लॉर्ड, एनेक्चर 6।
यस।
सहायक निदेशक बोलते हैं सेवा प्रखंड विकास पदाधिकारी गिरियक, शिला और राजगीर से रिपोर्ट मांगते हैं हुजूर। वहां से रिपोर्ट आता है कि इस माय लॉर्ड एनेक्चर 7 पेज 40, इस कार्यालय में इसकी जांच नहीं की गई। अभिलेख वर्तमान में भवदीय कार्यालय में ही होगा। सूचनार्थ एवं आवश्यक कार्रवाई हेतु प्रेषित। नेक्स्ट माय लॉर्ड, ये आता है सिलाव से हुजूर, जिसमें कहते हैं इस प्रखंड में न तो फर्जी भुगतान किया गया है न फर्जी अभिलेख तैयार किया गया है। सिलाव वाले 41 पेज। देन माय लॉर्ड, पेज 42 माय लॉर्ड, इसमें कहा जाता है कि उपयुक्त विषयक एवं प्रासंगिक पत्र के आलोक में सूचित करना है कि इस प्रखंड के राष्ट्रीय पारिवारिक लाभ योजना के।
अरे भाई, मिस्टर काउंसिल, what are you trying to say? You will look into the inquiry report and say that the inquiry report is false.
नहीं हुजूर, हम सो
Then
मैंने ब्लॉक से भी ऐसा रिपोर्ट।
you are coming to the High Court. It is an appellate. Is it an appellate body? No.
नो मैन।
Then whether this document has been was considered by them, or if you have not produced there before it, what can we do? These documents which you are showing here,
जी,
they should have been produced there.
वो तो हुजूर देखा ही गया हो हमारा लॉट, वहाँ देखे हैं उसके बाद के।
और देखने के बाद उन्होंने फाइनल वर्डिक्ट
जी।
अपना दे दिया व्यू।
वहाँ लगा हुआ था।
देन
माय लॉर्ड कहीं कोई मैंने कहीं नहीं
Then
कुछ
how
proof
do you
होता है
say
my
that
lord। और हुजूर एट दैट टाइम माय लॉर्ड
the findings of the inquiry officer are wrong?
दो
Are you saying that?
जो दो आरोप जो लगा नीचे वाले 6, 7 ये सब जो है हुजूर, 5 तो कहीं इंक्वायरी में आया ही नहीं, वो हुजूर वो भी गलत है हुजूर, हमारा सो कहना है।
गलत है तो that means he has wrongly read the evidence.
इसीलिए हुजूर हम ये दिखाना चाह
So
रहे थे ब्लॉक
that is what we want to know, that can we do that? What is the scope available for the High Court in departmental proceedings?
Under CCA rules, Your Lordship.
एक चीज और हुजूर,
Can we act as an appellate body?
नो माय लॉर्ड,
Then
अपलेट बॉडी डिवीजनल कमेटी
they, before the appellate authority, did you take up this argument?
देखे ही नहीं हुजूर।
Where is your appeal?
अपलेट ऑर्डर लगाया हुजूर,
Where is your appeal? Where you have taken this argument?
ऑर्डर लगाया हुजूर
Order तो आपने लगाया है।
जी।
ऑर्डर में आपने आर्ग्यू किया है, चलिए बता दीजिए कि ये डॉक्यूमेंट नहीं देखा उन्होंने,
हुजूर हम लोग तो
या एविडेंस में लगाया
हम लोग
था।
बोल सकते हैं हुजूर, लिखना तो हुजूर
आप तो बोल सकते हैं हाई कोर्ट में, पर वो डेलिक्वेंट को तो बोलना पड़ेगा।
जी ना, हम वहां भी लगाए हुए हैं हुजूर।
तो बताइए, आपने अपील पेश करी नहीं यहाँ पे, जो आपने अपील लगाई थी? अपीलेट ऑर्डर तो आपने पेश कर दिया उनके सामने समक्ष, जो आपने अपनी अपील पेश करी होगी
जी,
उसकी कॉपी लगाई है।
नहीं लगाया नहीं।
Then how can you take up that argument that it is perverse? You could have argued that it is perverse, that the concerned officers did not look into these documents, which were there on record. But you'll have to prove that.
Yes, ma'am.
Where is, from what document are you going to prove it?
One thing more, my lord. At that point of time, my lord, petitioner was initially appointed, my lord, only on the provision period में था।
Even that part
ज्ञान का
can we look into?
नया आदमी था हुजूर।
Who is to examine this part, whether a lenient approach should be adopted or not? It is for them. It is for your employer. There are some employers which are very strict. There are some employers which take a lenient view.
कहीं एक पैसे
How the court is going to interfere in that? What is this scope? गुणशेखरन का जजमेंट ही कही इनको 2012 को, the limit of interference has now been very clearly outlined, where the court can interfere, where it cannot interfere. 2012 का निकाल के दीजिए। And then argue within those four corners. If you can make out a case within those four corners, welcome. If not, it goes.
हुजूर दो आरोप जो कहा गया my lord, 7 और 8 के बारे में, 6, 7 और partly 8 के
So
बारे
it
में।
cannot be said that the inquiry officer did not apply his mind. He has applied his mind. He has looked into documents. He has exonerated you from all the charges, some of the charges.
Yes.
In some, he has held you guilty. In those which he has held you guilty, the disciplinary authority has agreed with his findings. It is not a case where the disciplinary authority differed from the findings of the inquiry officer. स्कोप बड़ा लिमिटेड है।
जी
बताइए।
हम हुजूर कहना एक चीज़ और चाह रहे थे हुजूर कि एट द टाइम ऑफ अपॉइंटमेंट, जिस समय ये प्रोसीडिंग स्टार्ट हुई हुजूर, उस समय उसका प्रोबेशन पीरियड था माय लॉर्ड, थोड़ा कम ज्ञान था। जबकि ये फाइल जो लिखा हुजूर वो पहले बड़ा बाबू के यहाँ जाता है, देन बड़ा बाबू के यहाँ से हुजूर जाता है एसडीओ साहब के यहाँ बगल। तो एसडीओ साहब हमारे लिए कहते हैं कि इनको सस्पेंड किया जाए, और बड़ा बाबू को कुछ नहीं, जबकि हम नया आदमी थे हुजूर। हम मात्र 2 साल हमको उसमें नौकरी का हुआ था। तो हम मान लीजिए हम कुछ हुजूर गलत हमसे हो गया तो बड़ा बाबू को देखना चाहिए था कि नहीं इसको ऐसे करो भाई वैसे करो, तो उनको कुछ नहीं किया गया और हमको सस्पेंड के लिए रिकमेंडेशन किया गया।
बताइए कोई कानून लाए हैं आप इस पॉइंट पे?
नहीं आया तो नहीं।
तो फिर कैसे मदद करते?
मैंने ऐसा इसमें आया है हुजूर कि बड़ा बाबू के मैंने उनके पास गया, उसके बाद फाइल प्रोड्यूस हुआ। तो इनका तो हुजूर चूंकि कम दिन का अनुभव था, अनुभवहीनता थी।
If you are in the court, then you bring some law in support of your submission that there is a discrimination vis-a-vis others.
My lord, some time दे दिया जाए हुजूर, हम प्रयास करेंगे हुजूर की लाइन खोज के। लाया नहीं हुजूर। और कहीं कहीं एक पैसा का गबन नहीं है, कुछ
Punishment is
नहीं।
there.
Now, if you have given him a minor punishment,
Minor.
how have you
He has
withheld
not
it?
pointed out that
How-
any
how have you withheld
formality has been committed in the
Mr.
conducting
Counsel,
of the.
for a minor punishment, you could not have suspended him.
No, we have suspended him.
सस्पेंड 20
Just a moment.
20 महीना
Now, please,
जी।
if a person has been suspended and after you have conducted an inquiry, you find that there is only a
Certain
minor,
Allegations
he deserves
are-
only a minor penalty, then you will withhold his salary for the subsistence period.
that is the part of the minor punishment, Your Lordship.
So,
Rule 14, Your Lordship.
it is there here.
Just a minute, Your Lordship. Part.
16,500. खाली सी बुक थी। Yes, you please read it.
Part 5 of the Bihar CCA Rules 2005, Your Lordship. Minor and major punishment. The following penalties may, for good and sufficient reasons, and as hereinafter provided, be imposed on a government servant, namely minor punishment. Number 1, censure, that we have.
All right, please.
Withholding of promotion.
Next.
Recovery from his pay of the whole or part of any pecuniary loss caused by him to the government by negligence or breach of orders. Reduction to a lower stage in the time scale of pay for a period not exceeding 3 years without cumulative effect. Withholding of increment of pay without cumulative effect. Without cumulative effect.
These are the penalties.
Yes.
No? I am asking you, how have you withheld the salary during the suspension period, apart from subsistence allowance?
Yes.
The suspension will not be treated as correct if he has been only punished for a minor penalty. Because for a minor penalty, you can't suspend a person. That's the law.
But at the time of suspension, Your Lordship,
At the time of suspension, you have rightly done it.
yes.
But ultimately,
conclusion of the
when you have
department-
passed the punishment order, at that stage you will have to examine whether the suspension was rightly passed or not. And you will have to take a decision at that stage. That decision seems to be erroneous.
that infirmity has not pointed out by the petitioner at any.
So he has challenged it. What more is
at
required?
any stage, Your Lordship, before the
Well,
appeal.
where else to point out before, apart from the court? Find out the law. You अब judgment लाइए या कर दे decide.
कर दिया जाए।
सिर्फ subsistence allowance तक का कर देते हैं. That is all, because the punishment has to be rightly been passed.
उसमें भी हुजूर 8 चार्ज में 5 प्रूफ भी नहीं है।
हाँ?
5 चार्ज तो कहीं प्रूफ भी नहीं हुजूर। 8वां चार्ज पार्टली प्रूफ है। 2 भी कहीं इसमें
Charges have been proved-
गवर्नमेंट मनी का कहीं लॉस नहीं हुजूर। नॉट ए सिंगल पैसा
Is
मांगा।
there a provision here? Rule 54 होता है under the General Service Rules and FSR. यहाँ की जो आपकी General Service Rules है उसमें subsistence allowance के बारे में कहीं दे रखा है?
नहीं।
हाँ, और decision has to be taken
देख
with regard
रखा
to
था मैं लोग।
subsistence allowance.
सीसीए रूल 10 में है हुजूर।
हाँ,
Subsistence
CC rules में होगा या तो यहाँ
जी 10 में है मालूम।
10 में देखिए पढ़िए please. Let us see what is the.
Yes, Lordship. Subsistence allowance during suspension. A government servant under suspension or deemed to have been placed under suspension shall be entitled to receive a subsistence allowance, an annual equal to the half average pay, and in addition, dearness allowance admissible on such half pay, provided that where the period of suspension has exceeded 12 months, the authority whom has made such order or suspension shall be competent to vary the amount of subsistence allowance for any period subsequent to the period of first 12 months as follows. Number 1, the amount of subsistence allowance may be increased by such a suitable amount which shall not be exceeding 50% of the subsistence allowance admissible during the period of the first 12 months, if in the opinion of the said authority, the period of subsistence has been prolonged, for which, for reason to be recorded in writing, the government servant is not responsible. Number 2, an amount of subsistence allowance may be reduced by such a suitable amount which shall not be exceeding 50% of the subsistence allowance admissible during the period of first 12 months if, in the opinion of the said authority, the period of suspension has been prolonged for which, for reasons to be recorded in the writing, the government servant is responsible. Third, the rate of dearness allowance will be based on the rates increased or the reduced amount as the case may be for subsistence allowance admissible under sub clause 1 or sub clause 2.
Mr. Counsel, not that.
That is
The period of suspension, please see that what is the, how the period of suspension is to be regulated.
Clause first, Your Lordship. The amount of subsistence allowance may be increased by such a suitable amount.
No, that is for subsistence allowance.
Ji.
How the period of suspension has to be?
Yes, provided that where the period of subsistence has exceeded 12 months.
No, that is subsistence allowance. Okay, here. Yes, please. After a departmental inquiry is over, then a decision has to be taken with regard to the period spent during suspension. How that has to be, is there no rule? There has to be some rule, because there is a rule under the general service rules in central government as well as in other states. I don't know about your state much, so that is there.
Rule 11 is there, Your Lordship?
Rule 11?
Yes.
Yes.
The treatment of service on reinstatement
yes.
and
that is what
pay
we,
and allowance.
That is what we want to know.
After suspension, Your Lordship.
What is, how does how does that deal?
Yes.
In case where a person has been made
When
to
a
suffer a
government
minor penalty.
When a government servant under suspension is reinstated or would have so reinstated but for his superannuation while under suspension, the disciplinary authority shall consider and make a specific order regarding the following: the pay and allowance to be paid to the government servant for the period of suspension ending with reinstatement or the date of his retirement on suspension, as the case may be. Whether or not the said period shall be treated as a period spent on duty. Notwithstanding anything contained in Rule 10 of these rules, where a government servant under suspension has died before.
Come to 3. Come to 3.
Where the disciplinary authorities of the opinion that suspension was wholly unjustified, the government servant shall, subject to the provision of sub-rule 8 of this rule, be paid such full pay and allowance to which he would have been entitled and had he not been suspended. While making such payment, adjustments shall be made in respect of successor allowance and other allowance already paid.
So that decision has to be taken, huh? Whether the suspension was justified or not.
Yes, Lordship. That decision to be taken.
That has to be taken under Rule 11.3.
Yes, Lordship.
That has not been taken.
Then Your Lordship may remand back this matter, Your Lordship?
Because
only limited to that part, Your Lordship.
Only to that.
Yes, Lordship.
That is.
If they have not taken any decision, Your Lordship.
Because this part is always, because if there is a minor penalty, you don't suspend. If proceedings for minor penalty had been taken, then there was no occasion of suspending the person. That is what is coming in mind. But of course, the decision has to be taken at your level. If the counsel for the petitioner, by way of this writ petition, challenges the punishment order passed against him, whereby he has been punished with stopping of 1 annual grade increment for withholding of 1 annual grade increment.
two
है प्रेयर में तो 1 ही लिख रखा
नहीं हो जो
46
पहला बार
holding
तो रोका गया था माय हाई कोर्ट के बाद
Page
फिर दोबारा
46
जो रिमांड
of the order
हुआ,
you
किया गया है।
Page 46.
हम बने को चैलेंज अभी किए हुए हैं बिफोर लॉर्डशिप्स एनेक्चर 17 माय लॉर्ड
Page 46.
withholding of
56
2
में
grade
पहला
increments without cumulative effect, and further warning to remain careful in future. Learned counsel, the petitioner has also been directed not to be entitled to salary other than the subsistence allowance paid during suspension period. The order dated 5/11/2009. ये तो 46 पे था।
पहले वाला माय लॉर्ड
अभी जो पनिशमेंट ऑर्डर है वो
पनिशमेंट ऑर्डर माय लॉर्ड एनेक्चर 17 पेज 81 माय लॉर्ड वो पहले हुआ था 2 इंक्रीमेंट काटा गया था माय लॉर्ड आफ्टर रिमांड जो है तब फिर ये आया एनेक्चर 17 पेज 81 माय लॉर्ड
लिखिए, काट दीजिए उसको, पूरा काट दीजिए. The petitioner by way of this petition assails the order dated 21/5/2011 whereby he has been punished with withholding of 1 grade increment without cumulative effect, and further it has been directed that he shall not be entitled to any payment apart from subsistence allowance during the suspension period. Para. The petitioner also assails the appellate order passed on 18/4/2013 whereby the aforesaid order dated 21/5/2011 has been upheld by the Commissioner, Patna Division, Patna. Learned counsel for the petitioner has submitted that earlier the inquiry was conducted without following principles of natural justice, and this court in writ petition preferred by him assailing the earlier punishment order, passed an order on 26 July 2010 in CWJC 18363/2009, Nipendra Kumar versus State of Bihar, wherein following directions were issued. Page 51, the order of punishment dated 5/11/2009 is therefore not sustainable. Stands allowed. After the matter was remanded to the inquiry officer, the petitioner submitted his defense before the inquiry officer, and whereafter the inquiry officer submitted his report. Learned counsel has taken this court to the inquiry report to point out
Actual 15
that he has been exonerated of charge number 1, 2, 3, 4 and 5. However, the inquiry officer has held charge number 6, 7 as proved and charge number 8 as part against him. Learned counsel submits that the petitioner was referred, has submitted his objections to the inquiry report and pointed out that the said charges have wrongly been proved by the inquiry officer. However, the disciplinary authority agreed with the findings of the inquiry officer and held him guilty of the said charges and proceeded to punish him with the aforesaid punishment. Learned counsel submits that the appellate authority also failed to take notice of the documents which he had filed in support of his defense in relation to the aforesaid charges and has wrongly upheld the order of the disciplinary authority. Learned counsel submits that a lenient view ought to have been taken with regard to the so-called alleged action of the petitioner, since he was a new incumbent in the office and was not aware of the day-to-day functioning, and for such mistakes there was no occasion to have punished the petitioner. Learned counsel further submits that the petitioner, who had been placed under suspension, has ultimately been punished with a minor penalty of stopping of 1 grade increment without cumulative effect, and therefore there was no occasion to withhold the salary apart from subsistence allowance of the petitioner during the suspension period. Learned counsel appearing per contra, learned counsel appearing for the state has supported the order passed by the disciplinary authority as well as the appellate authority and submitted that there has been no, that the petitioner was given due opportunity of hearing. There has been no violation of rule of the provisions relating to conduct of inquiry under Rule 17 of the CC rules, and the disciplinary authority has applied its might independent of the inquiry officer and reached to the same conclusions.
Rule 19, Your Lordship.
Keeping view thereto, the punishment awarded to the petitioner does not warrant any interference. Learned counsel submits that the appellate authority has also independently examined the appeal preferred by the petitioner, and the same also does not warrant any interference. So far as the question relating to the forfeiture of salary apart from subsistence allowance during suspension period is concerned, learned counsel submits that the order has been passed by the disciplinary authority which does not warrant any interference. आप क्या कह रहे थे? Rule 19?
Rule 19 is a procedure for imposing minor punishment.
That's another thing. Procedure adopted was under Rule 17. Charge sheet was issued under Rule 17.
My Lord,
I have considered the submission. Rule this court finds that after the remand, the disciplinary authority and the inquiry officer, the disciplinary authority as well as the appellate authority have strictly followed the provisions of the rules of 2005. Inquiry has been conducted wherein separate charges were examined independently, and on the basis of evidence which has come on record, the petitioner was found to be exonerated of certain charges, while has been found guilty of committing some of the charges. On the basis of the inquiry report, the disciplinary authority has agreed with the findings of the inquiry officer, and having held the petitioner guilty of charge number 6 and 7 and partly guilty of charge number 8, he has proceeded to punish the petitioner, awarding him a minor penalty. The appellate authority has also considered the aspect regarding the petitioner being a new incumbent in office, and has also noticed that the minor penalty has been awarded to the petitioner mainly because of this reason. With regard to forfeiture of salary during the suspension period, apart from subsistence allowance, this court notices that CCA Rule 11 is independent of the departmental inquiry proceedings initiated under Rule 17 or under Rule 19 of the rules. Rule 11 of the CCA Rules 2005, it would be opposite to quote Rule 11 of the Rules of 2005, which reads as under. From perusal of above, it is apparent that an independent application of mind is necessary after having awarded the punishment, to see whether the salary is to be forfeited or the complete salary is to be paid for the period spent during suspension to a delinquent employee. As per subclause 3, if the disciplinary authority is of the opinion that the suspension was wholly unjustified, the government servant would be entitled to the full pay and allowances, apart from less the subsistence allowance already paid. However, if the disciplinary authority reaches to a conclusion otherwise, then he will pass a separate order. This court finds that in the present case, the disciplinary authority has proceeded to pass an order while passing the order of punishment itself. He has not independently exercised his mind on the said aspect, nor he has given the petitioner any opportunity of hearing on this aspect.
Nor the petitioner has represented Your Lordship.
In these circumstances, this court deems it appropriate to set aside the said part of the order passed by the disciplinary authority of forfeiture of salary for the suspension period, apart from the subsistence allowance, and remands the matter back to the disciplinary authority to take an independent decision in terms of Rule 11 of the CC Rules of 2005, after giving an opportunity of hearing and also considering the fact that the punishment awarded is of a minor nature. The decision in this regard shall be taken within period of 2 months from the date of submission of the certified copy of this order. The writ petition is accordingly disposed of.
One thing more permit, my lord.
इन एक्सेल 2 से हुजूर जैसा हम दिखाना चाह रहे थे, my lord.
हो गए आके ये थोड़ी होता है perhaps.
Item number 30, Mr. Vindhyachal Singh.
Lords, I humbly pray for a Passover, Lords, for 1 week. Firstly, my Lord, sees in some personal difficulty and due to his absence, we cannot locate the file also, my Lords.
My Lord, file has not been served to the board, my Lord. Board is the main contesting party. My Lord.
Lords, I humbly request that my Lords may give a last opportunity, my Lords.
What is the nature of Home Guards? Is it not a volunteer organization here? क्या service है क्या?
My Lord, copy has not been served, my Lord, so I cannot say that what is the matter, my Lord. It may be related to the advertisement 1 of 12. I am just presuming, my Lord, because it is a case of 2013.
We want to know from you,
My Lord.
is a Home Guard service a volunteer organization here or a regular service?
No, my Lord, they are not in regular service, my Lord.
If it is a volunteer, how can it be?
My Lords,
What is the right of a volunteer?
I don't have a file, my Lords. My Lords may give a last indulgence.
Counsel for the petitioner does not possess the file and is also not able to locate the file.
No, my Lords, because the petitioner counsel is in some personal difficulty due to which...
You are not able to locate. No.
My Lords, in
It is
his
a court of
absence...
record. Whatever you say, it has to be recorded.
I bow down.
चलिए आगे
My
रखिए.
lord.
Wants time. देखिए simple. Counsel for the petitioner wants time. List after 2 weeks.
Sorry, my lord. Item number 6, that is matter relates to the district teacher appellate tribunal, my lord. Present position is, my lord, that I am extremely sorry to say that the present position is
Same as what it was that day.
no something, my lord. Situation will change.
They have not been made functional. Na? We have initiated contempt proceedings so moto against,
My lord, that is
against your chief secretary.
Therefore, my lord, I have asked the director that the matter.
That
after
we have
examining
given you time. If you make them functional by the next date, if you make them functional by next date, the chief secretary and the additional chief secretary need not be present.
Right.
We have initiated so moto contempt. If they do not make them functional by that date,
then
they will both remain present here and I am going to punish them. You be very clear about it. I don't mince my words.
Certainly, my lord.
It's a court of record. You can record my statement, what I am saying today.
My lord, my lord. If my
It
lord,
is 1 year that we have given you a very long rope.
my lord, certainly.
Nothing more.
That is.
You can't make a joke of your own rules. It is binding upon them to follow their rules.
Follow their rules, my lord.
Or you scrap your rules.
It is true, my lord.
We have given you time up to, what is that date? कब रखा है उसको?
2nd February.
हाँ.
2nd February.
First February.
सेकेंड हुजूर इसको कर दिया।
नहीं फरवरी फिर बिताना जिस दिन बितानी।
नहीं बिताना नहीं है फरवरी वो
That is 1st February and that is it.
फर्स्ट 1 फरवरी समझे ना बीन टाइम वो और फंक्शन हो जाता
है। It is very simple. The contempt has to be taken notice of within period of 1 year.
My
We passed the order in Suresh Ram on 23rd February.
my lord.
So the notice, so moto proceedings have been initiated mentioning this aspect. You can read that order.
My
Mr. Ramindranath.
Otherwise you will take a plea कि साहब 1 साल हो गया.
वो मेरा कहीं से भी मेरी कोई मंशा नहीं है। हम इतना ही चाहते हैं हुजूर कि ये फंक्शनल हो और हुजूर के आदेश से ये फंक्शन में आ जाता है तो ये जो है बेनिफिट
नहीं हमने तो आदेश कर दिया था पर लेकिन
नहीं वो आपके अभी जो स्थिति है
वो हिंदी में बोलना नहीं चाहते
क्या समझ रहे हैं क्या हम समझ रहे वो जीएटी के पास पेंडिंग है
ऑफिसर ऑफ व्हाट रैंक
डायरेक्टर प्राइमरी एजुकेशन
you are an IAS officer
yes
see what difficulties you will have to face
it is
starting up going up tell your chief secretary
Lord, it is in our department's earnest interest also that this
you will be see your ministers will never be responsible. The administration of the government is in the hands of the officers. It is you who have to see that they have to draw a line, say that no, further, no indulgence to anyone. You can't be playing politics in all these things. And you can't allow them to play politics. There's a duty towards the court, there's a duty towards people, and as per rules which you have already framed. Please convey.
Now it comes. Much obliged.
आपकी अटेंडेंस मार्क करें उसमें? उसमें जो पहले ऑर्डर आया था, उसमें आप आइटम नंबर 6 में आपके पास नहीं, पहले था आइटम नंबर 6 में आप अटेंडेंस मार्क कर लीजिए. Mr. Jha, along with the director, primary education, he informs that there has been no further steps taken for. Why? This is what you have informed. No further steps have been taken to make the district appellate authorities functional.
No,
although the selection process has already been completed.
Steps has been taken and the matter.
Although the selection process has already been completed.
My lord,
but appointments have not been made. Nor the selection district appellate authorities have been made functional.
The matter is sorted out and went for the GAD department, my lord. That
you have not said so. आप लिखित में दीजिए.
As per today,
you have not given it in writing.
Your Lordship, if I may apprise the court of the updated progress in past few days.
What happened after that minister said no?
Your Lordship, afterwards, with the indulgence of the court, the matter was sent to AG to examine it. The AG has opined that based on the merit list which was prepared, it need be re-examined on the basis of following of reservation roster. And the file was sent back to Additional Chief Secretary. He has, with the permission of the Chief Secretary, sent it to GAD, which is the main personal department. So the GAD is examining it on the basis of the reservation roster which was sanctioned, and it shall be done in a day or two, following which, if need be, will revise the final selected list based on the merit list as per the advice tendered by the GAD.
Is it a government service? How are you applying a roster?
Yes, Your Lordship. There has been a roster.
They are retired people.
But the roster is
you are appointing on a judicial post retired judges. Where is the roster applying here?
Your Lordship, the reservation rules state that
where is the reservation apply? अगर इस तरह से करने लग जाए तो हमारे तो सारे हाई कोर्ट की जजेस का सबका ही है ना रिजर्वेशन रोस्टर. आप कहाँ रिजर्वेशन रोस्टर लगाते हैं स्टेट अपीलेट अथॉरिटी में? From where did you get this new thing?
रोस्टर क्यों लगे उसमें? रोस्टर फॉलो तो करना नहीं रिजर्वेशन.
From where? Tell us. Young man, you tell us.
This is the based on the direction.
It will tell us from the rules.
Your Lordship, I'll have to go back and bring.
This is not an appointment as such in a service. A retired man is being appointed. It's essentially a nomination. It is not even appointment. Their tenure is fixed. Where is the roster application?
Lordship, this was the.
As a matter of fact, those who are senior or who are who have retired, they should be given immediate appointments. Others who are later on or who have already spent more time as in retired life, they should be taken up later on if you do not have any other person. That is how the process should be adopted in amongst the district judges. You have to appoint only district judges.
District judges and officers of retired officers of Bihar Education
that also,
and Bihar Administrative.
So where is the question of roster in their cases?
This was a post.
Even otherwise on the highest post and highest echelons of the post, I don't think roster is required.
These posts were.
We have already said it in Pradeep Kumar Gupta's case.
Your Lordship,
these are specialized posts.
Since these posts were created by the cabinet and they are paid by the state exchequer, so as per GAD rules, the reservation criteria which is applicable.
We want to know. I am only interested in getting those.
One indication, my lord, may kindly be given that the matter is before the GAD department now, personal department.
We don't know. We have called your chief secretary.
My lord, I have to seek one apology.
It is infructuous now, my lord. 30 months.
This has become infructuous.
Yes.
Also states that the writ petition has been rendered infructuous.
My lord, with hand,
I am apologetic with regard to my item number 5. My friend was there, 2 seconds was called, he went out to call me. By that time, my lord, naturally, what a grave. No one appears in 8 weeks, हुजूर उसको हटा दिया।
नंबर 38
उसको हुजूर कल लगा।
वन अर्जेंट
आगे रखा है क्या किया?
Pardon me.
आगे ही रखा है ना?
8 weeks रख दिया।
हाँ तो आगे रख दिया ना? ये तो है ही।
No one appears लिखा दिया गया ना, वो that will reflect.
तो appearance कैसे दिखा देंगे सब?
Great, my apology is to be accepted, my lord.
Sir, there is no apology here.
My lord.
Yes.
Under extraordinary circumstances, I am craving my lord's leave to mention a case of university service matter.
No, we are.
My lord, that I am knowing, my lord. That I am knowing, my lord. Urgency involved in this case is right from the year 1984 till yesterday I was in the service. Yes, on 18th, my termination order has been issued. I am on the post of university professor.
Your permission will get it listed.
My lord, sir.
Give your slip.
My lord. कल यदि रह जाता हुजूर।
आज के केसेस से?
आज लिस्ट पर है हुजूर।
तो आज के केसेस कल कंटिन्यू करेंगे? पता नहीं। कल तो वर्चुअल हियरिंग है वो तो रहेगा नहीं तो। It all depends. I don't know.
Then on Monday, my lord.
Let us see.
I am a university professor from 2004.
All right. So you give a slip, we will then pass it.
Obliged.
A lot of kind commission will. There is a matter in company Pirates Phosphates case. It is item number 1, IA number 112 of 2022.
This is it starts from item serial number 89.
Milan. It's in Pirates Phosphates case.
Serial number 98, item number 1.
98, item number 1, Milad.
Number 112.
Yes, IA number 112, Milad. In this case, I was to file an affidavit, Milad.
Where is that?
99.
Serial number 99.
99.
Item number 1.
When the case is called?
I just wanted a 1 week time in that case because affidavit could not come.
The other side is also there. Let us see.
Yes, I have informed otherwise state, but I will wait. But I can call her.
Original jurisdiction under heading 4, serial number 89, original criminal misdemeanor 1 of 2004.
Yes. फाइल दीजिए मेन फाइल ये
पिटीशन पीछे लगा
इसका कोई रिप्लाई होगा कुछ नहीं
एक्यूज नंबर 359
last time it was taken up of 23/8/2018 milord. This is original criminal miscellaneous milord. The Parswa mining milord was wound up way back in 1996 milord.
पार्श्व माइनिंग का नहीं है, कैमूर फाइनेंस का 1 of 2014.
1/2004 ये
परसों का है ना 89 सीरियल नंबर.
This is with regard
to 89.
ये पार्श्वा का है.
Parswa.
In this milord, 9 persons were made accused milord because they could not file the statement of affairs though company was under winding up milord. Out of 9 persons milord,
What happened later on? What is the present position? You have filed your reply?
Yes, milord. Show causes are there, milord. But
now, out of them, how many of them are left?
Yes, milord. 268 are dead, milord.
All right.
268.
205 petition was allowed in case of 4 and 7, and 317 petition for exemption was on 135.
4 and 7 is allowed.
205, they're dispensing with their personal appearance.
Personal appearance might be dispensed.
Yes, they will. But, my lord, what I say, my lord, the last instruction I had was way back in 2018. Till date, my lord, I have no. Let it be on next appointed day, my lord. I would verify and press there. All show causes are there, my lord. Still, a statement of affairs have not been filed, my lord, because their contention is that they are not in a position. They were not having at the relevant time, though they are painted as directors. They were not in session of the records of the year, and they, in spite of best efforts, they could not have filed the statement of affairs, my lord. It is by and
you could have, because he must have taken over the entire record. You could have gone there with him and got the statement of affairs prepared from the documents which are available in the head office of the company. That could have been done.
My lord, I'm after so many years, my lord, I'm not even aware what they have stated in their show causes, my lord. Let it be considered on next day, my lord.
You want adjournment?
Yes, my lord.
Accused number 359 have given discharge petition. That is to be also here, my lord.
I would go through the entire records, my lord.
The discharge petition for the reason stated, the personal attendance of accused 359 is exempted for today. List these cases again on date taking.
दो फरवरी को टेंडर है इसके बाद कितना फरवरी
2 फरवरी में टेंडर है 9 फरवरी को ठीक है नेक्स्ट
Serial number 90, original criminal miscellaneous 1 of 2005.
My lord.
Who is appearing for?
Accused number 1 and 3 have been expunged.
All right. And what about 2?
Accused 4 is expired.
And what about 2?
Accused 2 is absconding as per record.
Then?
Effort has been made. And almost all proceeding completed, but mispresence also pending in this case.
Against the same people?
Same.
So we close this case?
We want to close.
Leaking. The petition, this is an application filed to take criminal proceedings against the accused for having violated the provisions of section 454(5) of the Companies Act and having not submitted statement of affairs within the requisite time period as laid down therein. The accused respondents were the directors and the officers who were lastly posted on the board of directors of the company in liquidation. Which was engaged in manufacturing of hydrogenated vegetable oil. Stop. The company had been ordered to be winded up by this court, while it's order dated 7th April 95, in terms of the opinion of BIFR under section 20 within bracket 1 of the Second Industrial Companies Act 1985. The OL was appointed as liquidator of the company with effect from 24th April 95. It is stated by the learned OL that the accused were obliged to submit statement of affairs within the time limit prescribed, that is 21 days in terms of section 454 within bracket 3 of the Act of 1956. But in spite of the time having expired, none of the board of directors, namely the respondent accused, submitted their statement of affairs, nor they same were filed within the extended period as prescribed. No reasonable grounds have come forward for not having submitted the statement of affairs within the time prescribed, and therefore they deserve to be punished in terms of the said provisions. Para. This court had taken cognizance of the offence against the accused persons and later on discharged. A date बता सकते हैं? Later on charge 2 and 3
8/9/2020.
While order dated 10/3/2006. However, discharge number 4, accused number 4. As far as accused number 1, Om Prakash Chirania, is concerned, he expired on 2nd of August, 8th of September 22. And was therefore discharged, and similarly proceedings were closed as against Dev Prakash Rungta, who expired on 17th, who also expired. Proceedings were closed on 17/11/22 as against him. As regards accused number 2 is concerned, all possible steps were taken to secure his presence before this court, but for years together he has remained absconding, and there is no information about his whereabouts. The police authorities have not been able to search out, and even a standing warrant होगा, standing warrant has already been issued against him. Para. The company was wound up in terms of directions of the BIFR, which found that the affairs of the company were not possible to be continued in view that it had become sick and was not in a position to pay out its debts and liabilities. Stop. Since the order was passed in compliance of directions of the BIFR, which was having the entire details of the statements and affairs of the company, non-submission of statement of affairs subsequently in terms of 454 within bracket 3 may not be treated and considered as a ground to initiate criminal proceedings against directors if it would be reasonable for them to take an excuse that the said entire details were lying with the BIFR. Keeping in view thereto, the proceedings initiated by the court under 454 within bracket 5 of the Companies Act 1956 are found to be an unnecessary exercise in futility, and accordingly this court deems it appropriate to close the proceedings under 454 as against the accused. The same are brought. The standing warrant issued as against the accused number 2 is also closed.
Obligement.
Next.
Serial number 91, original criminal misdemeanor 3 of 2010.
Lordship, I am appearing on behalf of the ex-MD, Lords. Ex-Managing Director, Mr. B.K. Singh. Lords, earlier, Lords, on 30/8/2018, there was an order in this, Lords, because one connected matter, Lords, my Lords was hearing. I am led by Mr. P.K. Shaheen, Lords, that is fixed on 9th of February, Lords. As with respect to that land transfer, Lords, during pendency of
You want it to be fixed on 9th February?
It may be fixed along with it. I will submit at
9th February.
17 because since this is
The
an
personal presence of the accused is exempted for today.
Obliged.
Next.
Serial number 92, original criminal misdemeanor 5 of 2010.
Yes.
One statement has been filed.
When?
Somewhere around in 2017.
No, 2017 has 365 days.
Yes.
Somewhere is not the thing. You tell us when. You have the details with you?
Lordship, today I am not having brief that advocate.
This brief is not with you?
No, not. That's why date is not available with me.
For the learned OL wants time. List again.
Filing history, sir.
The personal, for the reason stated, the personal presence of the accused is exempted for today. Next. कब रखे?
The 4th of February.
When he is available?
First week of February. On second.
टेंडर सेकंड
पूरे दिन भर चलेगा क्या टेंडर?
कितने आएंगे कितने नहीं पता.
कितने आएंगे?
और भी मैटर पहले से फिक्स हो चुका है.
9th को दे दीजिए.
Serial number 93, original criminal misdemeanors 1 of 2014.
My Lordship, I am appearing on behalf of the accused Anil Kumar Singh. My Lordship, in this case, a statement of affairs has been filed.
What is your ground for delay?
Your Lordship, I was in jail for since last 10 years. And
You could not have filed. When was the
during that period, Your Lordship, when my company has been liquidated. and another director who was in charge of all the documents and assets of the property. He has absconded.
Who is that one?
Mr.
Shiv Shankar Chaubey
Yeah, Lordship, Shiv Shankar Chaubey.
or Vijay Bahadur Singh? Which one?
I am appearing for Vijay Bahadur Singh and Anil Kumar Singh, both, Your Lordship.
Okay. So both of them were in jail?
No, Lordship. Only
Anil Kumar
Mr.
Singh
Chaubey. Only Mr. Chaubey. Anil Kumar Singh was in jail, and Mr. Vijay Bahadur Singh, he was the only nominal director. He was not in charge of any documents, because this is a limited company. 3 directors is required. So
Shiv Shankar Chaubey was in charge?
In charge, Your Lordship. He is director of finance, so he is in charge of all the assets and documents of the company.
Okay.
So he has absconded. His trial has already expedited.
Now, what steps have you taken to get that statement of affairs done, prepared?
Yeah, it has been prepared. It is filed on the basis of the documents available in the office of the ROC.
Yes, we close it.
Yes,
Likhi.
6-year delay.
The petitioner has
No, 4 years delay. It is 2016 it has been
The-
identified.
6 years.
official liquidator has filed this application for initiating proceedings against the ex-directors under section 454 within bracket 5 of the Companies Act 1956, alleging that the respondent accused were the directors of the company when the company was ordered to be wound up by this court by its order dated 3rd February 2012. In view of the provisions contained under 455, 3, the directors are obliged to submit the statement of affairs within period of 21 days, but the same was not submitted in time, and in spite of notice given by the OL, the statement of affairs were not made available. In view thereof, he has prayed to take action and punish the accused in terms of the provisions supra. Para. Per contra, the accused number 1 and accused and number 3 have presented themselves before this court, and through their counsel they have submitted their explanation. As per their statement, accused number 1 was in judicial custody and therefore was incapacitated to file statement of affairs in the relevant time. As far as accused number 3 is concerned, it has been pointed out that he was only a director having no possession of the documents, having no actual working knowledge about the company, and was made a director as a family member.
Yes.
Learned Counsel has also pointed out that so far as accused number 2, Shiv Shankar Chaubey, is concerned, he was the Director of Finance of the company and was having all the documents of the company in his possession. He was therefore required to file the statement of affairs as soon as the company was brought under liquidation or was directed to be wound up. Stop. On account of his inaction, the accused number 1 and 3 ought not be penalized. The section 454 reads as under quote. In terms of section 454(3), it is therefore essential that within the time limit prescribed therein, the statement of affairs must be filed. The provision is mandatory in character. However, if there is a reasonable ground put forth, by the directors in delaying the filing of the statement of affairs, the same can be examined and the delay can be condoned. In the present case, the petitioner's counsel has pointed out about the incapacity and inability of the petitioner of the accused number. Counsel for the accused has pointed out the inability and incapacity of accused number 1 he being in judicial custody could not have filed the statement of affairs. It is also noticed that after having been released, he has already filed the statement of affairs with the OL, which is not disputed. As regards accused number 2, this court notices that the accused number 2 has been absconding and there are already standing warrants issued with respect to him. The delay in filing statement of affairs on the reasons stated above, is found to be pardonable, and accordingly the statement of affairs is directed to be taken on record. The delay is condoned. The proceedings under 454 within bracket 5 of the Act of 1956 are accordingly dropped. Notices and warrants are discharged. Next.
Serial number 94, original criminal miscellaneous 2 of 2014.
In this case, statement of affairs has been filed.
Yes, it's in fact 8 years 6 months delay, my lord. 8 years 6 months delay.
8 years 6 months delay.
Well, it's
they have been filed, huh?
Because I have.
What is the delay? What is the reason for delay?
Because I have explained that, and if your lordships will permit me, since this has a checkered history, because I'm filing a small synopsis of list of dates. Lordships will
You tell us why, what is it? There is a small point in.
Milos, the small point is, Milos,
it doesn't go beyond that.
Milos will just give me a small little opportunity, Milos. Milos, on 15/7/97, they passed prohibitory orders against us. In April 1998, Milos, they go and lock my office, Milos.
Where are those lists in dates here?
Milos, your lordships will find it, Milos. I'm on the second page of the list of dates, Milos. Item number 4 and 5. Now, the prohibitory orders are passed against the company on 15/7/97. On April 1998, Milos, they unilaterally locked my office because my headquarters are locked down. Then, Milos, and on 8/10/1999, that is item number 7, Milos, the Honorable Court admits the case.
It been wound up? Has the company been
2006, my lord.
When was it wound up?
21
December 2006.
Milos, the provisional liquidator was appointed on 8/10/1999. And thereafter, Milos, it was in 2006 that it was finally put under liquidation. Now, Milos, in 2004, on an application made by us Milos, the locks were opened and we were allowed to inspect our own records. And thereafter we filed our statement, Milos, which your lordships will find item number 14. (7/5/2004). Now here, Milos, on the basis of the statement which we filed, Milos, the official liquidator submitted his report dated 6/5/2004.
Where is the winding up order?
Milos, winding up order, your lordships, the first, the provisional
21/12/2006.
6. And Milos, your lordships, what is interesting, if your lordships will kindly see item number 14, Milos, allow me to read it, Milos. The company, having inspected its record and having obtained copies thereof, filed its statement of affairs and the balance sheet to the official liquidator under provisions of section 454 of the Companies Act. The official liquidator, after its due verification, submitted its report to the Honorable Court on 6/5/2004, wherein he had stated that the company had assets in excess of its liabilities. However, the Honorable Court rejected the said report by order dated 7/5/2004, thus recording it was rejected, Milos. The next column your lordships will see. Though the Honorable Court had rejected the report dated 6/5/2004, so submitted by the official liquidator, he was directed to go through the record and file a fresh report. It is stated that there was no direction to the company to submit a fresh statement of affairs and or balance sheet. The statement of affairs and the balance sheet so submitted by the company of the official liquidator had not been rejected. So, Milos, that statement of affairs, Milos, continues even till date. And thereafter, your lordships will see it, item number 18. The official liquidator, Milos, on 24/7/2007, as per the directions of the Honorable Court dated 10/5/2007, the official liquidator submitted a report dated 24/7/2007 to the Honorable Court. In this report, the official liquidator in paragraph 4 had stated as follows. The last part I am reading, Milos. The official liquidator at the end of his report prayed for a direction to the petitioner to furnish the title deeds and further to comply with the requirements in respect of the properties so mentioned in the statement of affairs which was filed earlier. Thereafter, Milos, on 8/10/2007, item number 20, Milos, the official liquidator, Milos, has been acting on that report, on that statement of affairs. The official liquidator has been holding personal interviews with the petitioner on 8/10/2007. It is stated that the affidavit dated 9/3/2004 formed the basis of the interview and the inquiry. Therefore, Milos, where is the question of...
No, that is a separate thing regarding personal interview and inquiry.
Milos, the basis of that is the statement of affairs which had been filed way back in 2004 itself, Milos. And that statement of affairs has been... Now, Milos, it's very surprising that the right hand of the official liquidator doesn't know what its left hand is doing. They had been acting on the same statement of affairs, which was before the Honorable Court. It was before them.
Now, who all are there?
Milos,
Anjani Kumar has expired.
Milos, one has expired, two have...
Rakesh Kumar.
Two have been...
4 and 5.
Milos, 3 we don't know. 4 and 5 Milos have been absolved. So there is absolved. So there is only one Milos, Sanjay Kumar Singh Milos, who is before your lordships.
Yes, anything. Now you have the statement of affairs.
We are having.
Oh.
But I have to verify if
When?
it is for 2004 or I have not seen 2004 statement of affairs.
In 2004, what you have not seen?
Because there was one small little issue which they were always raising, that the one which was filed in 2004 was not in the prescribed pro forma. So even that was done in 2015, my lords. And thereafter meetings have been happening. They have been acting on that, my lords.
All right. Likhi. This is an application filed for initiating proceedings under 454 within bracket 5 of the and 5A of the Companies Act 1956. Read with section rule 124 and 127 of the Company Code rules 1959 by the OL with a prayer to take action against the then directors of the company. The OL submits that the company was directed to be wound up by this court by an order dated 21/12/2006 in the company petition number 17/99, and the OL was appointed as the liquidator of the company. Whereafter, within 21 days, as per the mandatory provisions of section 454 within bracket 3, the respondent accused, non-petitioner accused, who were the directors of the company in liquidation, were obliged to submit their statement of affairs, and they having not submitted statement of affairs for a long time, the application was filed for initiating the proceedings. During the pendency of the proceedings, accused number 2 expired while proceedings were dropped as against accused number 4 and 5. Against 3 also?
3 is absconding, because we don't know where is it. This is whereabouts.
It is submitted that accused number 3 is absconding, and all possible steps have been taken to secure his presence, but to no avail. It is also informed that the statement of affairs has been now filed in the correct format in 2015.
2015.
After the filing of the present petition. Per contra, learned senior counsel appearing for the accused number 1 submitted that the Reserve Bank of India had passed a prohibitory order against the company, and the entire office of the company was taken possession of by the RBI and put under lock and key in April 1998. Petition was also filed by the Reserve Bank of India seeking winding up of the company. By order dated 8/10/99, the court directed the official liquidator to act as provisional liquidator of the company and to take steps for possession of the assets of the company. And in accordance thereto, possession of the head office of the company was taken under possession by the liquidator. As the accused had no access to the official records of the company, it could not submit the statement of affairs. However, the RBI nor the liquidator did not cooperate or provide access to the office of the company. And therefore, statement of affairs could not be filed. However, a payment proposal plan was also submitted before this court. The documents were allowed to be inspected and copies from the record under supervision of the OL on 12th February 2004. And the accused provided a detailed submitted a detailed affidavit giving details of the assets and liabilities of the company to the court with a copy to the OL. The official winding up of the company was directed on 21st December 2006, and again the official liquidator submitted a report stating submitted a report card. Again, official liquidator sent a notice on 2nd February 2007 for filing the statement of affairs. Ignoring the earlier statement of affairs and details given by the petitioner, the accused, on in 2004. In May 2004. See that it is further stated that on 8/10/2007 the accused presented himself before the OL and also gave out all the information relating to the company in terms of notice given to him under Rule 130 of the Company Code Rules 1959. The company, the OL was not accepting the earlier statement and wanted the same to be in the proper format, which was supplied to him in 2015.
Knowledge.
Date बताइए.
Well, that date, exact date is not with me.
2015. The learned OL does not deny the fact regarding having received the statement of affairs in 2015. Having noticed above, question arises whether there has been a delay in submitting of statement of affairs by the petitioner. However, this court finds that
They filed on 29 July 2015.
29 July 2015. The concept of filing of the statement of affairs in terms of 454 within bracket 3 of the Act of 1956 is essentially to make available the entire details relating to the company so that the OL may be able to know the entire assets of the company and also take all further steps with regard to the debts and liabilities of the company, and also for the purpose of deciding and adjudicating the claims. The ex-directors are supposed to help and provide all the information which they have knowledge relating to the company which has been directed to be wound up. The provision for punishment in terms of criminal law as provided under 454 with bracket 5 and 5A of the Act of 1956 is to make them directors sensitive to the essential requirement of filing of the statement of affairs in a timely manner. The delay in filing of statement of affairs can be condoned if there is a reasonable and plausible explanation coming forward from the concerned director. In the present case, this court finds that in 2004, even before the company was directed to be wound up, the statement of affairs, of course, not in the exact form, were made available to the provisional liquidator. A scheme was also proposed by the provisional liquidator for meeting out the debts of the company. Thus, it cannot be said that the liquidator was not having sufficient information relating to the company's affairs. This court, however, notices that the statement of affairs which was required to be filed in the correct format remained to be filed till July 2015, and there has been some material delay in filing the same. It is also taken note of that so far as accused number 1 is concerned, he was prevented from filing the same as he remained in judicial custody for a period from 2005 June to August 2007. Thus, up to August 2007, there was no occasion for him to file the statement of affairs. Whereafter, the record, he has been cooperating and presented himself before the OL and submitted his statement in terms of Rule 130 of the Rules of 1959. Having noticed all these aforesaid aspects, this court is satisfied that the delay is reasonably explained so far as accused number 1 is concerned. And view thereof, the quietus may be now given to these proceedings, and accordingly the proceedings are dropped and the matter is closed. Since the statement of affairs has already been filed, the notice is issued and bailable warrants are discharged.
Right, great.
Yes.
Obliged was grateful. Because now that the Malik of all the property, there was only one request that he should take care of that property because now that
I am taking care.
Because he needs to take a little more care.
I am taking serious
because most of the property is now being squandered away to encroachments, etc.
You move appropriate application.
We have already taken.
No, because I'm just taking an opportunity.
Matter
Obliged,
of serial number
grateful.
95, company petition 3 of 1984, item number 1, IA number 326 of 2022.
Your Lordship, this is for the modification only. To very little.
क्या modification चाहते हैं?
Modification, Your Lordship, I have filed.
10-11 का कौन सा order है?
10-11 का order जो
That quarter Dalmia Nagar eviction and
वो तो कर दिया ना हमने फैसला.
नहीं, उसमें पेज नंबर 11 पर
देवी का भी ऑर्डर इस पर आ गया सेम है इंटैक्ट है
As it is कर दिया.
लगभग वही लाइन
डिवीजन बेंच ने क्या कह दिया?
डिवीजन बेंच में हम जो गए हैं उनका पता नहीं, तो अभी हमारा तो कुछ नहीं है।
वो जो एक फैसला हो गया तो और अलग अलग होंगे।
वहाँ पता नहीं अब क्या, वहाँ भी तो वही हो रहा है, वो लोग सब मांगा जा रहा है एफिडेविट कि आप लोग कब खाली कीजिएगा।
वही होना है।
तो आज भी तो शायद है, तो ये 45 पर शायद आज है।
चलिए
45 पर आज भी है, चल रहा है। उन लोग को कुछ लोग दिए हैं, लेकिन मैक्सिमम अभी तक दिए नहीं है।
आप क्या करेक्शन चाहते हैं?
हमारा यह है कि उसमें जो पिटिशनर IA 3/2020 में तारा देवी का क्लेम्स जो लिखा हुआ है कि सी इज रिसाइडिंग एट इंडियन क्वार्टर फ्रॉम द ईयर 2001, हम 1983 से रह रहे हैं, हमारे पिटिशन में ही था। माई द हस्बैंड वाज एम्प्लॉय, 1981 he was employed, 1983 quarter was allotted to him, and from 1983 he is residing only to that extent. And nothing more.
An application has been moved for making correction, modification in the order passed by this court dated 10/11/22.
14/10/22/10/11/20.
Seeking a modification with regard to the year from which one of the applicant, Tara Devi, has been residing in the concerned
It's yes, /23/24. Yes.
belonging to the company.
Yes.
It is stated by learned counsel that she was residing from 1983, whereas it is mentioned in the order as 2001. It is informed by learned OL that the order passed by this court has been made as subject matter of challenge before the division bench, and the division bench has also passed an order on 4/1/23 in company appeal DB 8/22 in company petition 3/84 Amarnath Singh versus Messrs. Rohtas Industries Limited. Para. In Justice Lauti का जजमेंट था, क्या नाम से 2008.
Lordship, only one correction.
An order passed by a single judge gets merged with the order passed by the division bench in appeal. In so and so, the Supreme Court held as under. Keeping in view above, no modification or correction or review would be maintainable before this court after the matter is ये पेंडिंग हो गया, डिसाइड हो गया?
नहीं, पेंडिंग है लॉर्डशिप, फॉर समथिंग डिफरेंट है लॉर्डशिप हमारा है।
पेंडिंग आफ्टर द मैटर इज पेंडिंग बिफोर द डिवीजन.
They were unauthorized occupants. I am an authorized occupants. My application is not taken up before the division bench.
The order passed by this court would therefore the application moved for seeking modification of order dated 10/11/22 would therefore not be maintainable, and the same is accordingly dismissed.
Your Lordship, my humble submission that the 822 has been filed by another group of persons.
Might be anyone. Once it goes in TV,
they are in the group of unauthorized occupants.
अब हम आपको जजमेंट दे रहे हैं, आप उसको
I
पढ़
am
लीजिएगा.
authorized occupants.
आप उसको पढ़
My
लीजिएगा.
petition has not been taken as
आप
yet.
हमारे हाथ
Only to that extent. वो claims है. That is not.
आपके लिए तो Mr. Counsel, for you it is very easy to say.
It is only claims. It's not been decided.
Number 96, Company Petition 5 of 1992, OLR number 127 of 2022, regarding adjustment of payment to the secured creditors.
Single judge, double judge का Justice Lahoti कुनैया अहमद, उस पर नाम लिखो जी, कुनैया अहमद, केस का नाम in the case of Kunaiya Ahmed versus State of MP State Union of India. निकाल देना. Yes.
My lord, it is a payment of an interim dividend to SBI. Actually, earlier other secured creditors have been paid.
Is it what? First, second dimension.
Second, not. It is a first interim. That time SBI was left out.
Okay.
They not came forward.
So they have come later on.
They came to us, but in same proportionate they want us for.
Do you have the funds with you?
Yes, madam. But not sufficient fund because earlier.
Pari passu.
That
you are giving now.
Paripas.
But
But here difficulty is that, my lord, earlier interim payment was made to IFCI and IDBI was so much in excess.
That you adjust in the second this thing.
Second fund is lying,
See,
it's indisputable.
See, I had taken this for had passed an order directing the IDBI and they have to pass over the excess amount to SBI, to other bank in similar situation. But for that, you will have to give them a notice.
They have given undertaking that time. That
might have been, but then you will have to give them notice.
I have given notice. They appeared.
Milord, I appear for IDBI and IFCI.
So do you undertake to?
Milord, we do not dispute to the calculation. The only submission is, Milord, para 11 of the report itself, Milord. There is a dispute with respect to. I'll just place it, Milord, first. Lord, it says that as on date, a fund of rupees 1,55,90,422 is available in the account of the aforesaid company in liquidation account. 53,24,293 by way of realization through interest on FDs and 1,02,66,129 realized through rent. Now, whereas the amount realized through rent needs to be kept aside. So this amount 1 crore has been kept aside. As long as the litigation with regard to the assets of the company in liquidation is pending with local authorities, DM Gopalganj, Bihar. As and when the litigation is resolved, the amount being realized through rent will also be distributed on pari passu basis among the secured creditors with regard to their secured debts. Now, my lord, this is pending before this honorable court itself in the form of OLR number 20 of 2010 and OLR number 13 of 2014, in which we have also filed a rejoinder supporting the OLRs. The state is also appearing, they have also filed the counter affidavit. In fact, my lord, for part of the property which was already auction sold to the auction purchaser, there was a direction by the Red Court, my lord, once they had moved before the Red Court for renewal of the lease. So, my lord, to my understanding, my lord, this matter, my lord, at least for renewal of lease, will be, my lord, if it is considered, then this 1 crore will also be available for distribution, my lord. So, in that case, there will not be any requirement of taking money from us and giving it to the State Bank of India. Rather, my lord, there will be some money left for us also to be, my lord. So, I'll say that these two OLRs may be listed, my lord, and if it is heard, my lord, and if it is decided in our favor that the renewal of the lease has to be done, then, my lord, this 1 crore can also be distributed, my lord. This is what we are submitting.
State is ready to transfer the lease, but they are demanding some money.
So we will.
They are transferring fee. They are demanding transferring fee.
What
around
they are
1
asking
crore.
is, my lord, in fact, we have responded.
We brought forward that
transferring fees for
lease rent or something, outstanding lease rent. From the beginning.
12 lakh is the rent, 88 lakh is what they are claiming as interest over it. So, my lord, what we are saying is that 88 lakh, my lord, is an exorbitant amount of interest. Only 12 lakh rupees is the rent. We agree with that. If they want some interest over it also, we will not dispute to that. But 88 lakhs, my lord, as against 12 lakh of principal is, my lord, an exorbitant amount. That is what we are submitting. It is all pending before Lordships, my lord, in the form of these two OLRs in which we have also...
All right, we take up all three OLRs together.
Yes, yes.
Learned Council appearing IDBI and IFCI submit that the issue raised in the present petition ought not be decided in isolation, but should be decided along with the dispute which is pending before this court in the case of in OLR number
20 of 2010 and OLR number 13 of
2010 and
13 of 2014.
13 of 2014. The registry is directed to place this OLR along with OLR 20 and
13, my lord. 20 of 2010 and 13 of 2014.
20 of 2010 and 14.
Notices to DM also.
They are appearing. They have already filed counter affidavit. Yes.
Council appears for SBI.
District Magistrate, DM.
No, but anyone appearing for SBI?
No, today not. We have given notice.
Council
to all
for
the
Council for the SBI. We also notified of the said date. 16th Feb. Yes.
Serial number 97, company petition 11 of 1999, OLR number 124 of 2022 regarding confirmation of articles sold in a spot auction.
I know it's compliance report. Yep, so
the OL has submitted the report compliance of order passed by this court dated 8/9/22 with regard to sale of articles of the company in liquidation relating to articles lying in the registered office of the company at 3rd floor Udyog Bhavan, Patna, by conducting on the spot auction. It has been informed that after a competitive bidding between two persons, the articles were sold at a sale consideration amount of rupees 42,000. Which has been confirmed by the OL as directed by this court. The concerned purchaser auction purchaser has removed the auction sold articles on 5/11/22. The vacant room of the registered office is with the OL. Well, the report is taken on record and accepted. कर दे क्या इसी में कि to direct you to release the property.
That application is also pending.
हाँ वो भी तो
Disclaimer
pending है.
application.
उनकी जो एप्लीकेशन है स्टेट की, चलिए उसके साथ वो अलग से लगा दीजिए. इसके अंदर एक और है, उसको भी साथ में लगा दीजिए. हाँ
नेक्स्ट टाइम लगा
रिपोर्ट
डिस्पोज कर दो.
ये तो डिस्पोज ऑफ नेक्स्ट टाइम लगा दो, उसको रिलीज कराएंगे. व्हाई शुड ही कंटिन्यू विद दैट अननेसेसरी रेंट में भी आस्ट. चलो नेक्स्ट.
Serial number 98, company petition 4 of 2009.
Lord, in this case, my lord, in last week, my lord, after hearing counsel for the parties on the issue whether provisional liquidator appointed in 2000, whether to continue or not in case of Helios Corporation Limited, my lord directed both the parties to file the written arguments, my lord. I have
No,
prepared.
he said that you first part was with regard to, that is my observation with regard to this order, that as a division bench has passed an order that only relates to that interim order part will remain.
Remain, yes, my lord.
But so far as that liquidator part is concerned, that does not continue.
Yes, my lord, whatever be that, my lord, but that has to be considered afresh in terms of the division bench
Yes,
order.
so now
And
the main petition was required to be addressed to.
Yes, my lord.
And we asked him whether they filed any reply. He said that he was not having. They
Yes,
filed their reply.
But my lord also directed to file the written statement from both the parties, my lord, written arguments.
Written
my lord.
arguments, all right, we will take them. You argue first.
Yes, my lord, I have almost prepared it, but I need one indulgence, my lord, for
That you
finalizing
can
it.
even do later on. You argue. If I require, I'll take it. Otherwise, I'll pass an order just now.
That's why I'm saying, my lord, I have prepared the written argument. So almost it is prepared, my lord. I required only one indulgence.
Written
for finalizing.
arguments, if the court wants, then only you file it. It's not that you will force upon us
Last
the written
time-
arguments.
last time, my
Otherwise,
lord-
then we can very well
Yes, yes,
finish
my
off
lord.
cases by only looking into the file and deciding it.
Last time, my lord directed us to file, my lord. That's why I'm saying.
I said that you keep ready
So
if
the-
required.
So I need one indulgence, my lord. I have.
तो आप तो बहस तो करो.
Achha, my lord.
My lord, my office has received some complaint about Helios Corporation. Some properties are being alienated. I have given a report with an annexure of their complaint.
They have given an undertaking. It's there in the on record that they have not alienated any copy.
We have not alienated any property.
That undertaking is there on record. If that is said, then have they registered?
I annexed the complaint, copy of complaint.
टुडे फाइल कोर्ट में फाइल किया अभी कोर्ट में फाइल किया.
दे दो दे दो दे दो.
Apart from that, I would request, my lord.
ये करते हैं फिर केस हम चाहते हैं.
Apart from that, my lord, I may request, my lord, as on 2000, 2001, my lord, the position was there, my lord. As on today, when my lord is considering, as on today, whether the provisional liquidator to continue or not, my lord, their financial health, as on today, must be known, my lord. So they may be directed to file the latest, my lord. That is, my lord.
We will see whether, because you know the observation is very clear. We are, for us, he is no more there.
Yes, my lord.
In terms of the division bench order, you both are there. You please certify that I have to appoint him or not.
Yes, my lord, that is an issue, my lord. That is
So please argue.
Yes, my lord. My lord, as per, my lord, Reserve Bank of India is the petitioner, my lord.
Yes.
As per the petitioner, my lord, there are 4 grounds, my lord, on which, my lord, I'm just, my lord's indulgence, my lord. The 4 grounds of the petitioner RBI is that, my lord, the company is unable to pay its debt, my lord. Company, by virtue of provision 45IA of the Act, become disqualified to carry on the business of non-banking financial institution, as it has not applied to the bank for issuance of registration certificate to carry on the business of NBFC. The company has been prohibited by RBI to
Was it allowed earlier?
Yes, my lord. Prohibition
See, was it allowed earlier? See, there is a prohibition. You say that they have never applied for NBFC.
Yes, my lord.
So they cannot do it. Now, on what basis were they doing it?
They were accepting deposits in the name of industrial companies, but they were accepting deposits from the public. An inspection was made by the RBI, and office was inspected, and as a fact, it was found that they have accepted deposits. Therefore, a prohibitory order was issued that was challenged.
Deposits in what form? Deposits by way of payment of interest on that amount?
Yes, my lord. Yes, my lord. By payment of interest on that amount. Although they say later on they have converted it into debenture and bonds, and they are excluded from the purview of RBI. But we say, my lord, maybe that they are under SEBI control, but that does not mean that RBI jurisdiction is ousted, because as a matter of fact, on all the four grounds, my lord, after physical inspection, my lord, the binding up petition was filed. And my lord, they were found indulging in NBFC activities. First, they were prohibited. That order was challenged, my lord. That was confirmed by this honorable court.
Please show.
Yes, my lord.
Please show.
Yes, my lord, I'm showing it. I'm just one inconvenience. My lord may come to my lord, my petition, my lord.
Yes, yes.
Now, my lord, paragraph 7. Straight away come to paragraph 7.
Of your petition.
Yes. My lord has got it.
Yes.
That it is submitted that the bank deputed its officer in the month of October to conduct the inspection of books of accounts of the company as to ascertain the financial position of the company on March 31, 1997. It was observed that besides continuance of the violations pointed out in the prohibitory order dated 5/5, some more violations were also found, which are as under: financial position of the company, as and so, net owned fund of the company is in minus, net owned fund of the company, so and so, accumulated loss, so and so, reliable available assets, so and so, aggregate outstanding liabilities, so and so, aggregate deposits. Therefore, my lord, the liabilities were much more than the assets, my lord. Major violations observed during the course of inspection was also found, my lord, and following paragraphs were there, my lord. Company had invested only 5.4% of its total deposits in fixed deposits, as such violated para so and so. The company has not made any investment in government security, as such violated para so and so. Despite negative net fund both, my lord, and there are various shortcomings which was mentioned as up to item number I, my lord. Then, my lord, in paragraph 8, my lord, I have given, my lord, that on what ground it was filed, my lord. That it is submitted that
Yes, yes.
Now, my lord, paragraph 8. it is submitted that and under section 45A of the Act introduced with effect from 97 by way of amendment commanded the non-banking financial companies not to carry on the business of a non-banking financial institution without obtaining a certificate of registration of the bank. The company was expected to submit an application to the bank for issuance of such a certificate of registration, but the company had failed to submit its application for issuance of certificate to carry on the business of non-banking financial institution. As such, the company is not entitled to transact the business of non-banking financial institution as per section 45IA of the Act. Thereafter, my lord, there were complaints of the depositors also, that it is submitted that some of persons claiming that they are depositors of the company and its group of companies, namely Helios Finance Investment and Helios Chemical Limited, Helios Plantation Developers, filed an application under section 45QA2 of the Act and section 58 of the companies on the file of the Company Law Board, complaining that their deposits together with interest were not repaid by the respondent company and its group of companies referred above. The Company Law Board, by its order dated 7 of 99, directed the company and its group of company to pay the deposits in respect.
Did the company release these amounts?
No, my lord. No, my lord. In terms of Company Law Board order, my lord, it was not released.
Why?
They say, my lord, because of this.
Because of your prohibitory order or something?
They say, my lord. One of the reasons was that only.
So,
right.
So but ultimately, those people have suffered loss?
Yes, my lord, but they were...
Your action, you are on the question of law that they have violated your orders and the persons who had deposited, they will not get back the money.
My lord, but other persons...
And now if it is put to liquidation, they will never get it because then you will say that only the secured creditors will get it.
But pari passu otherwise.
Poor people who have given small deposits, 5,000 and 5,000 to 25,000, they will not be paid.
But illegality cannot be perpetuated.
Because of the provisions of law, can the citizens be deprived of their amount?
No, but many...
Can we apply such a law which will result in injustice?
No, my lord, but my lord, many more such citizens would have come under their net, my lord, because they were not...
Alright, so you have prohibited them from further. But for the purpose of payment of that amount, that should be released.
Yes, my lord, I have no quarrel with that. They were directed, my lord, but they say, my lord, unless or until this interim order goes, my lord, they are not in a position to pay.
Yes, Mr. Sanjay, no,
Yes. Let them pay. We don't have any quarrel with that.
Why don't you meet out with those liabilities?
No.
You were having this impression that the OL is holding the charge. Provisional liquidator.
There is a saying, you can't have your cake and eat it too. Now the RBI, my lords, I will show. My friend has been arguing in a very haphazard way, where he has not put the facts. There has to be a dateline for everything. Now, if your lordships will permit me, my lords, I'll place in two fashion. I mean, my argument would be in two manner. Manner would be in two this thing. First is dateline, and the second is whether it is legal. Why I say so, my lords, I'll demonstrate. My lords, what is the admitted position as per my friend, which is what the argument which he has placed? He says, my lords, he has placed 7 and 8, paragraph 7 and 8. Now, if your lordships will kindly see 7 and 8. My lords, 7 is a list of everything wrong that we have done in terms of violation of RNBC Directions 1987. Now, if your lordships will find 2A, violation is para 61A, 61B, likewise 61C, so on and so forth. So, the violation is of RNBC Directions 1987. And because of these violations, I should be wound up under section 45(1)A. Now, because this is their argument, and therefore they are saying that we need to be wound up statutorily. Money is not the issue here. What is the issue is that we did not register ourselves under section 45(1)(a), and therefore we should be wound up because we have done certain wrong under the directions, RNBC directions of 1987. Now, Milords, the question is whether these two are applicable to me. Now, why I say so? Your Lordships will permit me, Milords, I've made a synopsis. Where is the course copy? Yeah. Milords, may I kindly have a.
Yes.
Milords will kindly see the dates. And these are the admitted positions, Milords. 15/11/1995, Milords, we are registered as a company, Milords, with the ROC Bihar. And we are given a registration number. 29/11/1995, Helios Corporation commences its business. Now, Milords, the RBI undertakes an inspection of our company records under section 45(n) of the RBI Act on between 26/2/1996 and 29/2/1996. Milords, merely 3 months after we had come into business. Now, Milords, this exercise is on the premise that respondent company is functioning as an RNBC. Even before, Milords, there is anything against us by way of show cause or anything, they declare it that we are a RNBC. Now, RNBC, Milords, is residuary non-banking company. Milords, on 15/7/1997, they passed prohibitory orders against us from taking any deposits. Thereafter, Milords, on 16/2/1998, Milords, some depositors of the Helios group of companies approached the company law board for repayment of their deposits. Milords, the key words are Helios group of companies, not Helios Corporation alone. Helios group of companies. A while ago, Lordships have just discharged one of my directors of Helios Finance, Milords, which was an RNBC and a non-banking company. So that was also before Company Law Board. Now, 16/2/1998, some depositors of the Helios group of companies approached the Company Law Board seeking their refund of money. Milords, October 1998, the RBI, Milords, goes ahead and locks our office. Under what provision, under what powers, we don't know. But they go and lock our Helios Bhavan, as it was called here in Patna, which was our head office. It was locked up, so all our businesses were shut down. Whether it was Helios Finance, Helios Chemicals, Helios Corporation, whatever, it was just shut down. They took over the entire building, Milords. They put it under their lock and key. Thereafter, Milords, I'm giving these dates, Milords, these will be necessary. Milords, on 28/9/1999, the Company Law Board passes its final orders giving a scheme of repayment, wherein we were supposed to make payments till August 2000. Milords, I'll show that order to your Lordships. It is the next.
And that is what he was showing, no?
Milords.
5,000 to be paid and 25,000.
Milords, he is showing it from his petition. I'll show it from the order.
All right.
That what it was. So the last day for me to pay my depositors was August 2000. Milords, on 24/3/2000, they go ahead and preempt the order of the CLB, Milords, by filing a winding up petition before your Lordships, purportedly under the Reserve Bank of India Act, Chapter 3B, which relates to NBFCs. Now, where have we faulted, Milords? If I may ask a question to myself, why didn't you allow us to go ahead and honor the order of the company law board where you were also appearing. It's not that RBI was not there. RBI was very much there. Now, if I hear, Milos, if I may take the liberty, Milos may kindly see the order of the CLB, Milos. Milos, it is at page 41 of the brief. Milos, page 41. I'm on the brief, Milos. The brief of the winding up was not mine.
Yes.
Now, Milos, your lordships will see page 41. Milos, about 5-6 lines from top. In the matter of Messrs. Helios Corporation Limited. Milos has it?
Yes, yes.
Milos, they have given the case numbers. Shri Sanjay Kumar and 159 others. There were only 159 people of Helios Corporation depositors who were before the company law board. We had to pay only 159 Milos or 160. But Milos, for Helios Finance, if your lordships will see, Mr. Shri Lokesh Kumar Sharma and 5,238 and others. So majority were of the Helios Finance, which is already in liquidation. It is lying with the official liquidator. So I had to repay only 159 Milos. Now my lords will kindly have a look. Milos at page 42.
Yes.
Milos, the order, the first paragraph, about 3 lines from the bottom of the paragraph Milos. The applications came up for hearing from time to time on 16th February 1998. Milos, this date is important. February 1998. We are before the company law board under the statute, under the Reserve Bank of India Act also, Milos, and under the company law also. There are provisions to that effect. And Milos, what happens? In October 1998, they go ahead and take the possession of my entire premises, my whole office. Who is preempting me from paying, Milos? With due respects, Milos, it's the RBI.
October 98, they take over.
They take over. And it is documented.
All right. Yes, yes. Where is RBI party in this?
Milos, it is.
Assistant Manager, Department of Non-Bank, representing the RBI Patna.
Milos will find. In the matter of the very first line, Milos, at the top, in the matter of Reserve Bank of India Act 1934, section so and so, and in the matter of Companies Act so and so, Milos. Milos, on the next page, Shri Biblendu Pal, Assistant Manager, Department of Non-Banking Supervision, representing the RBI Patna. Page 42, about 4 lines from the top. Milos. Mr. Biblendu Pal, Advocate. Pal, Assistant Manager, Department of Non-Banking Supervision, representing the RBI Patna. Now thereafter, Milos, your lordships will come to the My Lords, page 45 of this order.
What is SF and IL and HCL?
Sorry, my Lords. My Lords,
SF and IL is Helio.
Helios Finance and Investment Limited,
And
and
HCL?
HCL is Helios Corporation Limited.
You are here for HCL.
HCL, my Lords. Helios Corporation. Now, my Lords will kindly see at page 45 how they proceed.
Yes.
My Lords, at page 45, bottom of the page, my Lords, A, 7A. HF and IL and HCL shall repay the deposit in respect of 5399 applications together with up-to-date interest and at the contracted rate and filing fee in the following manner. Now, my Lords, out of these 5399, my Lords, we were only 159 there, HCL. Deposit up to rupees 5,000 shall be paid by this 31st December 1999. On the next page, my Lords,
So these directions could not be complied with.
these directions could not be complied with because everything went into the hands of the Honorable Company.
Now, when you had an order passed by the High Court Division Bench,
My Lords.
after that, what have you done?
No, my Lords, I'll come to that. My Lords, first, your Lordships will allow me to demonstrate, my Lords, now how this is illegal. It is not permitted by law. RBI could not have done this, my Lords. The legal premise on which they have filed the winding up petition, my Lords, is not there. If your Lordships will just permit me that.
All right.
Now, my Lords, if I may take your Lordships to the Reserve Bank of India Act 1934, your Lordships will recall that the petition of winding up, my Lords, has been filed under section 45 MC and and 433 of the Companies Act, my Lords. My Lords, there are catenary of judgments, my Lords, which says that under 433, any winding up is not there available on mere asking. It is not. It cannot be just passed in a very matter of fact way, my Lords. It cannot be done that way. Now, my Lords, they are claiming a statutory right, a right under the statute or powers under the statute for winding up. Now, that power comes to them from section 45 MC of the Reserve Bank of India Act 1934.
RBI.
Yeah. Yes.
45 MC, my Lords. My Lords, has it? My Lords, it says, power of bank to file winding up petition. The bank, on being satisfied that a non-banking financial company is unable to pay its debt, A, or B, has by virtue of the provision of section 45(1)(a) become disqualified to carry on the business of a non-banking financial institution, or C, has been prohibited by the bank from receiving deposit by an order and such order has been in force for a period of not less than 3 months. And D, the continuation of the non-banking financial company is detrimental to the public interest or the interest of the depositors of the company. Now, my Lords, your Lordships will recall, my friend was placing the petition before your Lordships. It has been very candidly and explicitly stated that they are seeking this winding up under A, B, C, D of 45 MC, my lords. Therefore, I have not been able to pay the debt. Therefore, there is no registration under 45(1)(a), C, that they have been prohibited, and D, that it is in public interest. Now, my lords, before I go to the unable to pay my debt, your lordships have seen that I was stopped from paying that debt because my friends have intervened even before the order of CLB could be given effect to, my lords. So, it cannot be said that I was not able to pay my debts. I was stopped from paying my debts. Now, my lords, B is very important. My lords will please take the book again. My lords, it says 45(1)(a) become disqualified because I have not been registered. Now, my lords, 45(1)(a), my lords, came into existence only on 9/1/1997. This is very important, my lords. My lords, at the bottom of the page, my lords will find inserted by Act 23 of 97, Section 3, with effect from 9/1/1997. My lords, likewise, Clause 6, the violation of which of the residuary directions, my lords, RNBC Directions 1987, if your lordships will kindly see, my lords, at page 30 of the brief, my lords. I'm sorry, my lords, I'm taking your lordships up and down the brief.
Page 30?
Page 30, my lords.
These are some residuary directions of.
Yes, my lords. Now, my lords will see column 6, my lords, clause 6.
On and from May 1st.
On and from May 1, 1997. So these two dates are very important, my lords. And I am being proceeded with even prior to these two dates for violation of the provision of 45(1)(a) and clause 6. Now, how I say so, your lordships will kindly see. My lords, I am show caused. And the date of show cause, my lords, annexure 2, your lordships, just after that. Annexure 2, my lords, page 34.
All right.
Now, your lordships will kindly see. My lords, show causes nowadays, my lords, are something like a junjuna that it has to be doled out. Therefore, my lords, annexure 2 at page 34, my lords will see the subject. Dear sir, residuary non-banking companies Reserve Bank Directions 1987, contravention thereof. Now, my lords, this notice is dated, your lordships will see at the top of the page, 4th of January 1997. RNBC clause 6 comes into existence on 1/5/1997. I am being noticed on 4th of January 1997 for violating the provisions of the residuary non-banking companies. My lords, may kindly see paragraph 2. Your company was allotted by Registrar of Companies, Bihar, an industrial classification code pertaining to a financial company, namely residuary non-banking company, under the captioned direction and was therefore required to comply with the provisions contained therein. Then, my lords, paragraph 4. it is observed that your reply under reference and the memorandum and article of association unaudited financial statement as on 31st March 96 furnished wide your letter dated 15 June 1996 that your company has contravened various provisions of the captioned direction as enumerated below. 1. Not investing any amount in fixed deposit with public sector bank and in approved securities against your deposit liabilities as per the requirement of 10% and 70% respectively under the provisions of subparagraphs 6.1a and 6.1b IBID. Thereafter, my lords, on the next page, at page 35, your lordships will permit me.
Yes.
As the net owned fund of your company was negative, so and so, other investment under para 6.1c IBID made by your company was not in order. Now, next three lines are very important, belows. Moreover, your major investment in land at Patna and Dhanbad with an intention to construct and run hotels, which was non-financial activity, was also not in order. Now, why I read this is, belows, that because I claim myself to be an industrial company and not a financial company. Now, I will pause here, belows. I very categorically, in my counter affidavit, I have been very categorical. Every place I have been very categorical that I am not an RNBC, I am not an NBFC.
So if you take deposits.
Because I'm coming to that. I'm conscious of that deposit part, belows. I'll come to that. I'll come to that. Now, my lords, who am I then? I am an industrial company. You recognize that, yes, I am an industrial company. But doing business of finances, why? Because I take deposits. This is their logic, my lords. Now, to deny this logic, my lords, or to dispel this logic, my lords, this
presumed to be a NBFC.
Yes.
Sorry, my lords?
If you are depositing amount.
Yes, on interest taking money, my lord, we presume that.
My lords, I'll explain that.
There is some provision for presumption?
Yes, my lords, it is. There is. I'll come to that, my lords. The lordships will just give me the liberty, my lords, to go in my own way. Because then things will fall. Now, my lords, why I am saying that I was buying land in Patna and Dhanbad for hotels, etc. Because these are also one of my business which I wanted to do under my memorandum, my lords. Now, they have read only one part of the memorandum, that is taking finances, etc. Therefore, RNBC, but not the industrial part, my lords. Your lordships is aware that memorandum of association generally contains whole lot of businesses, my lords. Not necessarily one business is specific.
Yes.
So there were businesses, but be that as it may. Now what happens? Now, my lords, 6.2 IBID, 6.3 IBID, all this, my lords, I am being noticed about something which is going to be implemented on 1st of May 1997, on 4th of January 1997.
That we have taken.
Still born, but still. I am being asked to register myself as an RNBC or an NBFC under 45(1)A, which is still to be born on 9/1/1997. That your lordships have seen inserted in the Act. Therefore, my lords, 45(MC)B goes, because things cannot be put to me retrospectively. So this thing goes. So I don't need to be registered because the provision of registration on that particular date was not there. So I cannot be penalized for something which was not there at all. Now, having said that, my lords, your lordships will next see the prohibitory orders.
My lord, may I have it on the next day?
Yes.
Well, the prohibitory order, my lords, which is Annexure 3 at page 37. Fellows may kindly see the subject again. It says, residuary non-banking company Reserve Bank so-and-so 1987, contravention of provisions thereof. So I was noticed for this on 4/1/1997. Prohibitory order is coming after after 1st of May 1997, when RNBC Direction Clause 6 comes into existence, and this prohibitory order is 15th of July 1997. And your lordships will see paragraph 3. Your company was allotted by Registrar of Companies Bihar an industrial classification code number, they didn't give the number, pertaining to a financial company, namely in the residuary non-banking company under the caption direction, and is therefore required to comply with the provisions of contained therein. And then, my lords, 5 and 6, clause 5, my lords, they go and say that, I have violated clauses 6, 1, 6, 2, 6, 3, etc., etc., etc. of the and then, my lords, they go ahead and prohibit me from taking deposits. Now, my lords, cutting the long story short.
Yes.
My lords may kindly come to the same book, my lords, and come to 45I.
Yes.
My lords, may kindly see A. In this chapter, unless the context otherwise requires, A. Business of non-banking financial institution means carrying on the business of a financial institution referred to in clause C and includes business of non-banking financial company referred to in clause F. My lords have seen that. Thereafter, my lords will see BB, deposit. Deposit includes and shall be deemed always to have included any receipt of money by way of deposit or loan or in any other form, but does not include 1. Amounts raised by way of share capital, amount contributed as capital by partners of a firm, amount received from a scheduled bank or a cooperative bank, etc. My case is, my lords, that the deposit which I have taken is in the nature of debentures, my lords. Optionally OFCD, optionally fully convertible debentures.
Where do you say that?
My lords, I'll come to that. Because I don't have to say that, because that's a quasi-judicial authority has held that, because I'll place that before you.
In that order which you were reading?
No, not there, below.
SEBI order.
Below SEBI order. Now what happens below is that while this company petition was going on before, your lordships have seen that this has been hanging fire for last 22 years. Because in 2012, 13, 14, Milos, that date is not specific, but in 2015, Milos, SEBI passes an interim order against us for the same reason that we have not paid our depositors. That order is before your lordships. Now they hold that this deposit which we have taken is an industrial deposit in terms of OFCD. Now that, if your lordships would like to see today, Milos, I'll show it right now.
We'll continue.
We'll continue. Yes. Because I am caught between the sun and the sea, because SEBI has also gone ahead and made each of the directors now liable.
No, my lord, RNBC directions are of 87. So maybe that registration was not required, but as a Central Bank of India, we had issued directions. So all those companies which were indulging in accepting deposits on interest were mandatorily to follow those directions. And those were of 87, not of 97. 97 an amendment came whereby for very purpose of doing that, my lord, a registration with RBI was necessary. But earlier to that, those directions were there and very much enforced.
My lord, I'll answer that also.
And my lord,
I'll answer that also.
when we are having, my lord, next
week.
Next week, my lord, 26th, we have.
Next appointment.
We are having a chutti. So.
Second, my lord.
Second.
Third, second.
And we would be giving our written argument.
Yes. You give your written submissions also. इसको इसके साथ ही